Hello, everyone. Can you hear me?
Hello. Yes, I hear you well. Maybe others can just type quickly in the chat. Yes? Okay, seems it
That's
works.
great.
Okay, I mute my microphone.
Yeah,
The floor is yours.
thank you. Well, first of all, thank you to everyone for joining this meeting. As we heard, the meeting will be recorded, so don't hesitate to share with your colleagues and other people you know who might be interested in hearing more about this topic. This webinar forms part of Promise 2, which is an EU co-funded project which promotes the European Barnahus model. And for those of you who are not fully acquainted with what Barnahus is, it is a multidisciplinary interagency service for child victims and witnesses of violence, where different agencies that have a responsibility to protect and hear and support the child gather under one roof to support the child through the criminal investigation and judicial process, and to provide assistance. In 2017, in June, we launched the Barnahus movement. And this was a launch of a large network of Barnahus throughout Europe. I'll just take a minute to introduce myself very briefly, and then I will let Rebecca introduce herself when she starts her presentation after my very few slides. As you've heard, I'm Lydia Lind Hallersson. I am a co-founder of Child Circle, which is a small center of expertise based in Brussels. And one of the things that we have been working on recently is the Promise 2 project. And the vision here is Europe where human rights of children to protection from violence are supported and where their rights to be heard are fulfilled. And that's really where the European Barnahus movement wants to go to through the establishment of Barnahus in Europe. And these are our partners in Promise 2, and I am really pleased to say that we are in the process now of submitting Promise 3, which will focus on establishing a European competence center and training on, among other things, forensic interviews and therapeutic interventions. And we're also very excited to announce the launch of our Barnahus network in November. And if you go to the Children at Risk.eu website, you can find out more information about that. And before Rebecca starts, I just want to say that Promise has been a great journey for us all. When we started in 2015, we had some 6 or so countries with Barnahus, and now we're expecting about 20 countries or more to have similar service or Barnahus active in the coming years. And most of these Barnahus have either contributed to, have translated, or are using the Barnahus quality standards. And I encourage you to visit the link to find out more about these standards, because they really frame the work and the practice that we want to promote in Europe. That's all for me, and I will now hand over the floor to Rebecca, who will speak about a very important aspect of our work in promoting child-friendly justice and assistance to victims.
Speaker is working. Hi, good afternoon, everybody. So my name is Rebecca O'Donnell. I'm an Irish lawyer based in Brussels, working with Olivia in Child Circle. So it's very good to be with you all this afternoon. So this webinar is called At the Crossroads, and it is very much about how do we design and implement child-centered proceedings from the perspective of the criminal justice process when child victims of violence are involved. What we're going to look at in the next while is how the child protection proceedings and the justice proceedings intersect when we have a child victim of violence in a case. We're going to look at what problems or challenges that can cause for the proceedings. But we're also going to look at the law, guidance and practice that allows a more child-centered approach. We'll spend some time focusing on the interview with the child and the provisions that underpin it and the practices. And we'll do a little sightseeing at the end and look at some of the practices and resources around Europe that are developing. Don't hesitate to use the chat if you have a question to flag. If I can pick them up as we go, I will, and otherwise I'll return to them at the end of the slides. Okay, so first of all, I just wanted to ask everybody here to share with all the participants what type of work concerning child victims of violence are you involved in. You may be a legal professional, or we may not have professionals on the call this morning or this afternoon. Social services, psychologists, law enforcement. You could be involved in design of law, policy and guidance. That might be because you're working with an advocacy organization or you're a practitioner, academic, research, etc. And just to say, this webinar this afternoon, I'm sorry, I keep saying that. This webinar is very much based on workshops and conversations we've had with all types of practitioners that are working with child victims of violence. So I can see we have people from social services, we have some from the legal profession, and on the policy side as well as the research side. And some of our workshops have also involved very closely the psychologists who in some countries are involved in the forensic interview. Okay, so thanks everybody. Very interesting to see. So when we think of the criminal justice and child protection processes in cases involving children, I mean, we are often looking at two distinct processes, and they're usually governed by different laws, different policy frameworks. They're led by different actors. You'll have the law enforcement and the prosecutors, and then the judge involved in the justice process, whereas of course maybe the social workers are leading on the child protection side with the involvement of health professionals. They involve different time frames, and of course we know they vary. Those time frames vary across countries, but very often, you know, you might have a very protracted criminal justice process. It can sometimes take years to get to trial. The child protection process itself is often also long, but they usually overlap a little, but they don't coincide directly. So obviously the best interests of the child is involved in both, and of course certain professionals may be involved in both. You may have social services being called to testify at a criminal proceedings. You may have therapists in some countries being asked to give evidence in court. And as I said already, although each proceeding may begin and end at different moments, of course they overlap and run in parallel. So, you know, really we see sometimes two processes distinct from each other, running in parallel, and a little separate. This, of course, can give rise to some problems. If they operate independently of each other, they can in fact sometimes undermine each other. delays in interviews, repeated interviews, sometimes by law enforcement, sometimes by social services for the child protection processes. The interviews may be in different locations. They often happen with different people. And as I said, courtroom testimony sometimes occurs years after the incident. So you have these delays, and that can give rise to stress to the child and delay in the justice process. Evidence can become less accurate, less reliable through repeated interviews. So that causes problems for the justice process, for the prosecutors, for the case itself, for the defendant. And of course, any delays can give rise to delays in therapy. And there's a risk that the child will be re-traumatized if they've been through therapy and then subsequently have to go back and revisit the issue in the court. Now, I know many of you are very familiar with this. And in fact, it would be very interesting to share a little the challenges you see in your jurisdictions. So it may be that you can see lack of coordination between the legal and social professionals. I don't know whether you see delays for children in giving evidence. As I said, sometimes that can mean, that the reliability of the evidence can become an issue, and that means defense lawyers may be challenging the testimony, and of course, children being re-traumatized. So it looks like these problems, certainly the coordination is obviously a problem, and the re-trauma as well. Thanks for sharing that, and don't hesitate to add some thoughts in the chat if there are other challenges you can think of. We're very keen to hear more. Now, these are the classic problems, and in recent times, the law has encouraged and indeed has required a more child-centered approach to be taken to these cases. In the first phase of the Promise Project, we developed the compendium of law and guidance, which should be useful to people who want to learn a little bit more about what the legal foundations for a more child-centered approach are. We have the Council of Europe Convention on Child Sexual Abuse. We have EU directives, both specifically on child sexual abuse, and the broader EU Victims' Rights Directive, which came later. Of course, from the child rights perspective, we have the UN Convention on the Rights of the Child and the accompanying guidance that comes from the UN Committee on the Rights of the Child, which is very interesting in this area. And as we'll see, there are some judgments, including judgments from the European Court of Human Rights, that are very relevant to anything that happens in these kinds of trials. The principles that we see in the law, and again, let's bear in mind that these are recent laws, so some countries are still implementing them, and it may even take quite some time to see them really reflected in actual policy and practice. But a very big feature of the EU directives and the Council of Europe Convention has been that when a child is involved, the state must take a comprehensive approach to the situation. So, of course, the state responsibility involves preventing crime and prosecuting crime. But these directives and laws also recognize that the state has a responsibility to provide assistance to victims and promote their recovery. So it's entirely explicit in these laws that states must adopt provisions and practices that avoid secondary victimization and traumatization for victims. Of course, we're in a criminal justice setting, and any changes or adaptations to the procedure must fully respect the rights of the defense. But another kind of new features that we're seeing are, again, explicit requirements in the law that professionals involved in the cases should be trained. And this is a recognition that specialized skills are sometimes necessary in this field, particularly in the forensic interviews. And again, it's quite recent, but there is this recognition, increasing recognition of the need for a multidisciplinary and interagency approach. Now, that it can be quite a new and indeed alien and sometimes unwelcome idea in a criminal justice process, which is used to being to having a judge in command, in entire command of the process, and the four walls of the process involve, you know, the question in front of the court, which is, you know, the innocence or guilt of the defendant. But really, we need to think about what does a comprehensive approach require of the justice process. And guidance and indeed law increasingly shows that the protection of the child is also something that criminal justice proceedings must bear in mind. And we'll see that this can lead to some very, very specific practical questions for the professionals involved. So they were the principles. Now, looking at what does that mean in terms of the procedural obligations, some of the key safeguards and some of the points that really make a criminal process more child-centered are as follows. There's a requirement that there be an individual assessment of a child's needs. So that's very important, that when a child victim is going into a criminal investigation and potentially a court, first you need to really identify what safeguards should be in place, what processes should be in place to properly address the needs of the child and indeed the rights of the child during that proceeding. I'm sure many of you know firsthand stories where the child's needs really aren't properly considered, that it's just a child suddenly finds themselves involved and absorbed into a criminal proceeding without any real consideration of what might make that easier for the child, appropriate for the child even, and as we said, avoid re-traumatisation. Another specific safeguard, there shouldn't be any unjustified delay between the reporting of the crime and the interviews. There's an obligation that premises should be adapted to the needs of children, and that's important, and let's come back to that. Limited number of interviews. So the idea is certainly to avoid repeat interviews, and we'll see that that's done in different ways in different jurisdictions. And as I mentioned previously, special training to interview children is an obligation. The recording of interviews and the possibility to use the recorded testimony in trial instead of requiring the child to be present. That is a safeguard that must be available to the criminal justice proceeding. It doesn't mean that it inevitably will happen in any case, or indeed in every case or in any case, but it has to be available to the court. And as we see under national law, increasingly in some jurisdictions, that is coming into play. You need to avoid contact between the victim and the offender, and there's an obligation to provide support for the child in the proceeding. So these are the key safeguards that need to be available. I say available to the criminal justice process because there are provisions which allow for some exceptions or which allow some discretion to national courts. But clearly, these are the safeguards that Europe is moving towards increasingly. Now, it would be just interesting, again, to understand a little bit what type of child-centered safeguards you see in your country, if you're aware of them. Just mention the key ones here, whether or not you're familiar with individual assessments happening ahead of the investigation or the trial, especially adapted premises. I mean, we do see, of course, an increase in special rooms or special rooms in police stations or in the court. Okay, we see We've seen answers on the video recording of interviews, so that's an obligation that you're familiar with in some jurisdictions, and testimony to be given outside of the court. Yeah. So interesting. I'm optimistic that in a few years down the road, we'll all be hitting the 100% button on all of these safeguards, and maybe even thinking about new ones. But listen, thank you for that. Almost none of these in France, I see. Thanks, Karen. Well, let's just say then there's potential for great progress and hopefully rapid progress. Thanks, Karen. Okay, so we've seen that there is a framework of laws that really is pushing countries towards more child-centered provisions. We've seen the principles and the actual procedures that should be available. So let's turn a little bit to the practical questions. And again, these are questions that we've heard in the workshops we've undertaken. And they're the questions that in day-to-day practice people are concerned with, whether they're the prosecutors or whether they're the law enforcement. So if we really have these safeguards, how they impact the proceedings. I mean, obviously, by the way, a big starting point for most people is what will these cost? But apart from the cost, people ask, will they delay the proceedings? You know, if I have to make sure that a child is seen in an adapted premises, do I have to book a premise? Where is it? Is it, you know, in the capital of the country, or are they available throughout the country? If I need to have trained professionals, where are the professionals? Are they free? And how does any delay correspond with the need to do all of this as rapidly as is appropriate in a timely way? Because we know delay causes problems both for the child's situation and the proceedings. Another question that comes up is if you do have a child in a special premises, so not in the police station and ultimately maybe not even in the court, that setting is probably going to be less formal. It may have couches, depending on the age of the child. There may be cushions and things for the children to hold. So in a less formal setting, will the child tell the truth? Will the child realize they have to tell the truth? I mean, these are situations where the heart of the case against the defendant may come down to the child's testimony. So we really need to make sure that the setting doesn't affect the value of the testimony. And people also have questions in their minds, law enforcement, judges, you know, what special skills really are needed and why are they needed for the interview? And let's come back to that in a moment. Again, if other actors are involved, if we have a psychologist involved, for example, if we have social services involved in the forensic interview that will be used for the purposes of the criminal justice proceeding, are all of the actors impartial, or is there an inbuilt bias towards the child that are in front of them? Some questions occur. Defense lawyers might say, okay, well, are these actors really going to test the word of the child, or are they going to go too softly for the testimony really to be strong enough? And then another very practical question for law enforcement: if they're interviewing a child, and the interview is going to be recorded and used in court, obviously anything shown in court has to abide by the rules of evidence in court. So, so you can only ask certain questions, and you can only ask them in a certain way. But will that make it more difficult for the police to ask other types of questions that are important for the ongoing investigation? So that's been a real concern for some of the law enforcement involved. So moving on, let's look at some of the practical responses, as it were, to these issues. We talked about the delay. We talked about, you know, having to wait for adapted proceedings or having specialists available. What we have seen in jurisdictions where there is where these safeguards are really applied in daily practice. The start of the process and throughout the process involves careful planning and coordination. And if people pause to do the planning and to do the coordination, they can avoid some of the pitfalls that would happen in these cases at the best of times. So planning starts also with the individual assessment. Planning will make sure that you don't have repeat interviews to the extent possible. And planning allows the coordination, the proper coordination of the criminal justice proceedings and the child protection proceedings, so that someone in the criminal justice proceedings is aware of the fact that getting the evidence and recording the evidence from the child and making sure that evidence, the recorded evidence, can be used in court means that the child can start therapy. So, you know, doing all of these things is necessary, because if you start therapy, and in particular certain kinds of therapies, and the child then subsequently has to testify, the defense may argue that the evidence has been corrupted by the therapy. If the therapist has been asking about the event, if the child has been recalling the event in therapy, if they are then asked to recall the event again in the court, the defense may argue that the child's recall has been in some way distorted or affected by the therapy. So planning and coordination means you can avoid these kinds of difficulties, or should be able to avoid them. We talked about adapted premises or child-sensitive setting. Now, the directive itself acknowledges that these kinds of child-sensitive settings may be less formal, but that reduces stress. And in fact, the impact on the child's testimony can mean that less stress can mean less inaccuracies in the testimony. If the child is stressed in a very intimidating setting, or in a very uncomfortable setting for a child, that can lead them to be inaccurate or unreliable. That kind of a setting also allows the interviewer to build the trust of the child, and the trust of the child is often necessary to enable a child to disclose abuse. Often a child may have lived with and understood that what has happened to them is a secret, and they've lived with that secret, and it takes a lot for them to open up with that secret. So in order for a child to even disclose the abuse, you need that kind of trust. So the importance of a child-sensitive setting cannot be overstated. Going on to what is it like to achieve best evidence in an interview? We often hear the phrase achieving best evidence when we're talking with criminal justice professionals. We have, you're all familiar with different kinds of criminal justice processes in Europe. Sometimes you have, as in England and in Wales and in Ireland and in other jurisdictions, adversarial proceedings, whereby in court you're really pitting the testimony of a witness against the defense. In other countries you have more of an inquisitorial approach where the judge and the prosecutor are setting out to find out what happened, and the interview and the investigation reflects that difference in the roles. In the new directives and increasingly across Europe, we're getting closer to a truth-seeking process in the investigation. And that is why specialist skills and structured approach and using special interviewing techniques to get information have come more into the spotlight. I mean, obviously the specialist skills rely on an expert's knowledge of the child's cognitive skills, memory development, communication skills. And that knowledge means you can get more complete, reliable and accurate information from the child for the court. And getting more complete information also is good for law enforcement, because it may allow the investigation to follow up on particular forensic details that have come up in an interview. Indeed, these skills allow an interviewer sometimes to uncover the absence of abuse or to reveal coaching. There are a lot of case studies behind each of these different points. Moving on, of course, vital to the criminal justice process is that any safeguards put in place for a witness or victim don't undermine the rights of the defense. The justice system is there to avoid and must avoid miscarriages of justice. And we have seen court cases in Strasbourg in the European Court of Human Rights where the court has had the opportunity to examine these kinds of interviewing processes. In other words, where a child was interviewed and the testimony was taken down away from the court and the written record was produced to the court. And the court found that if the defense has had the opportunity to put questions to the child through an intermediary or to seek cross-examination on the points, in other words, the defendant has essentially had the opportunity to question the version of the witness as vigorously as they need to, then it is okay that the child is not in the court. And the defense's rights do not require the child to be brought to court and cross-examined in court. So that's very important and helpful jurisprudence. It's also useful to recall that, with the advent of modern technology, with video recording, it means that, the prosecutor and the defense lawyer together can, in advance of the court case, in some jurisdictions where the rules permit this, they will look at the recording and they will be able to kind of bookmark the pieces of the recording and agree on the bookmarking of the recording that will be put before the judge in the court and sometimes the judge and the jury in the court. So if we think about recording the interview, what are the benefits to the actors when we do record the interview? I mean, obviously, a key result of recording the interview is you have an accurate record of the interview. Before, when an interview had to be transcribed or notes had to be taken down, there was a real risk of inaccuracies. And now you have a very complete record of the interview. And again, seems very prosaic to say that obviously recording the interview allows the interview to concentrate on the questions and not on taking notes. But that's very important during the very sensitive process that goes on when you're interviewing a child. You can really focus on interviewing the witness and not simply on trying to play catch up and write down what's actually been said. If you record the interview and the interview takes place close after the incident, the recorded evidence then provides the evidence that is gathered sooner to the incident, and so when the child typically would have better recall. What's also interesting, and this was made in a submission in Scotland when they were considering law reform and the issue about recording was being discussed. And one of the submissions made, and I thought it was a very interesting one, was that if you record the child giving evidence just after the incident, the recording will show the judge and the jury, if the jury is involved, what the child looked like and how the child behaved around the time of the events. And you won't have in the court an older or a changed child testifying. It could be several years later. A lot may have happened in the child's life. sometimes, you really do have a different child in front of you, and that may if a child, for example, has got into difficulty with juvenile justice since the abuse, they've had a difficult life, the way in which their testimony comes forward may be a bit different. And so the point being, if you record the child giving testimony around the time of the incident, you really get better evidence, as it were, of the incident itself. Now, recording evidence also means that the prosecutor pre-trial can review the recording and give advice to the law enforcement, if indeed this is how it's done in your countries, on whether or not the evidence is reliable enough and sufficient to bring a criminal proceeding, or whether more evidence is needed. And I am looking at some of the comments coming in. Thank you to Daniel. So what are the views and experiences on situations when guidelines and safeguards for taking statements and actions can affect or increase the protection of children? Let's come back to that. When young people are perpetrators of criminal offences, yes. I mean, indeed, just to say, there is, of course, the other EU directive focusing on safeguards that need to be in place when children are accused or suspects. And we can come back to that if we have time. But there are specific guidance there, and that directive is not yet transposed. So we may see more practice emerging in the coming years. I'm going to crack on because we have just 15 minutes left, but I'm nearing the end. Just to continue very quickly on some of the benefits for recording the interview. Obviously, if you have an interview that is recorded, it can physically be made available for child protection assessments. There are obviously also maybe rules about whether it can be made available under the law. But there is the possibility that you would avoid a repeated interview for the child protection assessment. And then, as we said, if an interview is recorded, it may avoid entirely or reduce the need for further interviews with different interviewers, and avoid inconsistencies or, in some cases, fabrication, which may be deliberate or inadvertent. We've talked about the fact that recording the interview may avoid delay. It's important that if you are video recording, you have to really properly capture the room. It needs to be clear who's in the room, because that can be very important for the judge and the juries, to show that the testimony was given freely. Again, what looks like a prosaic point, the recording needs to be authenticated as digital evidence and properly stored, is in fact a real logistical challenge for some systems, and we'll see a little bit more about how jurisdictions are approaching that. Then let's look. Indeed, let's go straight into looking at that. We have these are just illustrations of some of the things we're seeing, and as part of this project, we are putting together a written briefing which will signpost some of these issues and some of the resources that could be useful to you in whatever your role is in your countries in looking at this issue and trying to promote progress. In Scotland, there is a new bill for vulnerable witnesses, which enables greater use of pre-recorded evidence. In Scotland also, there's been a focus on digital vaults in Scottish courts, making sure that Scottish courts are able and have the technology to receive and view the recorded evidence. Also, how do we see progress being made? In England, they have guidelines on achieving best evidence. And those guidelines were reviewed to see what is happening in the implementation of the guidelines. And that review really revealed the need for better suited interview premises, more planning, more training, and better handling of digital evidence. So those kinds of reviews are very important to pushing forward better practice and identifying how that better practice can happen. Worth mentioning, in the UK, there's the new Lighthouse Initiative, which is a new initiative very much focusing on implementing these safeguards, and we'll be very keen to hear from their experience. I think maybe some of the Lighthouse people are on this call, and don't hesitate to share with us your experiences. In Ireland, again, another, thanks Emma, good to have you here with us. In Ireland, police inspectorate reports in Ireland on the back of tribunals and reviews in child abuse cases have led to recommendations which include the establishment, a recommendation that 2 multi-agency child advocacy centres be established on a pilot basis. And indeed, that is happening as we speak in Ireland. There is a new one house premise being set up in Galway. Guys, in the chat you'll see Emma Herwood from the Lighthouse has kindly added the Lighthouse website for you to explore after the call. And of course the Promise website carries news of all of these developments and really encourages everybody to share what's going on in their jurisdictions. Okay, fantastic. Okay, and in Ireland, I see Sean is saying they've decided to call it a Barnahus. Okay, good, interesting. More sightseeing very quickly. Training practices. The Norwegian police have very specialised training, and again, that came out of reviews, and we're very grateful to the Norwegians for sharing their experience within the Promise project on the training. Again, on training, we're seeing the developing use of child avatars in training to allow people improve their skills for interviewing children, and that's an ambition in Promise 3. We're very much hoping to have more, to have the child avatars as part of the knowledge and competence centre that Olivia spoke about. Going back to England, these are things some of you may be interested in looking up. I mean, there is prosecution guidance on therapy before trial, which notes that the justice proceeding should never prevent therapy starting for the child, but it also identifies what kind of therapy might affect the evidence. And it discusses in what way evidence might be sought from therapists in the courtroom itself. And just, yeah, ending with one other experience, in the Netherlands, forensic medical examinations. I've spoken less about that because I've focused on the interview, but of course, another key element for the criminal justice proceeding is evidence from any medical examination of the child. And again, in the Netherlands, very specialised medical skills are being brought to bear on the examination of children involved in these kinds of cases. And that kind of specialisation really helps identify the nature and cause of injuries, sometimes showing that maybe an injury that is alleged to have arisen from an abuse could not have happened from an abuse, but actually more likely happened from something else. So that's very interesting and useful, obviously incredibly important to the court and the justice proceeding as a whole. So, I mean, again, we were having heard a little bit about the different developments in countries, and again, just to underline, it's a small sightseeing tour. Maybe you can think a little bit or share, what do you see as the potential for progress in your country? We heard from France that there's plenty of potential for progress, if I can put it that way, because as you mentioned, those safeguards aren't yet in place. But yeah, whether or not there's more room for child-friendly premises, more widespread use of video recording, specialized interview techniques. People are maybe either those interview techniques are already used or people don't see the potential for involving specialisms yet. Of course, maybe that comes through the training of the professionals as well, training of professionals in these techniques. It manifests in different ways in different countries. In some countries, intermediaries are used, like a psychologist who wears a headset, and the prosecutor and the defense lawyers can ask questions in the headsets, but sometimes the police themselves, only specially trained police working on these cases and building up experience, are interviewing the children. Okay, so thank you very much. That's very useful and interesting to see. Okay, I think it's worth ending and just noting that there is we know what the legal obligations are, the principles, the obligations, the specific procedures, but how do we fulfill these legal obligations in a day-to-day way? And there's growing recognition and more guidance on the need for a multidisciplinary and interagency approach to make this happen. And elements which have been referred to in international guidance include having integrated services in the same location. So having social services, health professionals and law enforcement in the same location and in a child-friendly setting. Again, these guidelines sometimes from the Committee on the Committee on the Rights of the Child, some from other UN agencies, some from the Commission. They talk of standard operational procedures among professions, because ensuring that professionals understand each other and understand each other's roles will foster that cooperation. There's also reference to coordinating mechanisms, having case management systems. So these are all examples of how we can do better and what tools we need to do these things better. And just to end, of course, in the hope that you'll, for those of you that aren't already familiar with the Barnahus model, that is at the heart of the Promise Project. There are different ways in which the Barnahus, or the Children's House, is organised across Europe. But the core common features are indeed that it involves specialised services and competent personnel. It involves that case management, interagency. All of the services are under one roof and the child encounters them in a very organised way. And of course, in the Barnahus, you have the involvement of the judges, the prosecutors, the defence lawyers, so that you ensure that needs and the requirements of the justice process are not neglected, and that we preserve the integrity of that process, and equally that the child can be referred to necessary services for therapy. So from Ireland, Joseph, I see that Ireland involved by state police and child protection services, and this is working well in implementing Barnahus. Okay, but unheard of at frontline child protection practice, unfortunately. Understood. And what we've also seen is, of course, this is an area where progress is usually incremental. You have a starting point and, putting in place the foundations, and then more training, and then better processes, and then it becoming more extensive across countries. So glad to see there's the foundations are in place and the beginning is there. Maud has asked, is there something specific for children with disability? In many Barnahus, the needs of all children are planned for ahead of time. So, and just to say, I've heard of one of the directors of a Barnahus, just before this premises was opened up, literally crawling through the centre to see how they would encounter the centre if they were a baby, being wheeled through on a wheelchair, just to really see, is the premises suited and adapted for children with all kinds of needs. So in an ideal setting, this would really account for children with in all situations. And it is an important standard, part of the Barnahus standards. You'll see the Barnahus quality standards refer to the fact that, of course, it should be set up that way. I am thinking that that was the last slide, but we come to this picture, this image that I hope we can all have in our mind. Remember that the intersection we saw previously, and the two processes basically in parallel are cutting each other. And here we have a more child-centered process, which allows us really to work together and to have the child's experience at the centre, while also necessarily serving the needs and requirements of the justice process as well. I'm going to finish at that, leaving all of 2 minutes for questions, which is very generous of me, I think. I apologise, but hopefully we took some of the questions as we went. Very keen to have your comments or your thoughts, and thank you, of course, for your input and your attention. I'm going to encourage people to get in contact with any of their thoughts. It's a really good time to share with us your thoughts, your questions, concerns, because really we'd hope to bring that into the resource document that I mentioned. You can raise the issues. If we can find answers, we will. If we can't, we'll leave the questions there, and hopefully it'll become a living document where we can continue to share experience within the network. But thank you all. Great. I don't know whether chat up. Yes, Katrina. Hello. Thank you.
Okay.
Thank you, everybody.
Thank you very much. Well, I mean, it was absolutely very interesting, and I can see that also it was interesting for participants. We talked the full hour, so many thanks for Olivia and Rebecca for doing the webinar with us, and many thanks to all of you who actually stayed the full hour with us to discuss this topic. I hope it was useful, and maybe we can, now you see on the screen a poll. Please let us know how you liked it, and also if you have any feedback or recommendation for us. So this is all that we had for today. I wanted to let you know that certificates for this webinar, for attendance of this webinar, are available. All you have to do is write to us on email. I will now put in the chat box. So now you should be able to see it, info@childhub.org. Let us know that you attended the webinar today and you would like to receive a certificate, and we will send you one. Just before we go, there is the web link section that you can see. I will move the poll so that you can actually see the web link section, and there is a note, Child Hub webinars. If you click there, you can see some of our upcoming webinars, one coming on June 20th, and soon there will be one more announced on June 27th. This webinar today was done jointly with the Promise project. The other webinars are done on different topics, but you can search and see if anything is still interesting for you to join. Thank you very much all, and let us know if you have any comments for us in the poll you can see on the screen. I wish you a great afternoon and a great rest of the week, well, tomorrow, and a very wonderful weekend. Goodbye, everybody.
Goodbye, everybody.